All right, we'll move to our next agenda item. Uh, let's see, we are on to an agenda item that was requested by this advisory group. Various members of the advisory group had asked us to give an update on our investigation and discipline process. We had done so several years ago, and I'm sure it needs updating and reminding folks of that process. I know that some of the details of it sometimes um, slip my mind as I ask questions of our next presenter, Bill Thomas, from time to time on various aspects relating to our processes. But I appreciate the fact that the industry has asked for this, and we're very happy to have Bill Thomas with our Enforcement Operations Branch joining us today to give this presentation. So welcome, Bill. Thank you. And I don't know, yeah, we're almost in the afternoon hour, so I'll still say good morning to you.
Yes, I was going to keeping an eye on the time to be aware of whether to say good morning or good afternoon. So I'll start with good morning. Thank you, Pat, for allowing me to make this presentation, for asking me to make this presentation. As we get through it here, I think you'll see that delving into this and preparing the material for this presentation enabled me to take a detailed look at the settlement processes within the Enforcement Operations Branch and to get a sample of where we're at on our settlement, and I was pleased with what I saw. So with that, we'll move on. One other thing real quick, though, I do want to acknowledge that I got your joke, Pat, about the missing cat. It was funny, and I'll give you acknowledgement for that. So, into the investigation process, I initially did a presentation, I want to say it was April of 2018, at the April of 2018 advisory group meeting, and it talked about how BAR initiates an investigation and proceeds with that through the adjudicated process. This presentation will follow up on that a little bit and then covers the next step in that, which is how we arrive at disciplinary terms. So to initiate an investigation, if a field office determines that violations of the Automotive Repair Act may have occurred, they're going to speak with their supervisor or field office representative and discuss the feasibility of proceeding with an investigation against that automotive repair dealer. Some of the things that could trigger an investigation include a pattern of complaints or complaint trends revealing a pattern of violations. Often we recognize a need for an investigation as a result of an no-charge auto body inspection performed for a consumer. We do receive a lot of anonymous tips. Our smog check cases often are triggered through smog check inspection data we receive from our engineering group and through other sources. Once the investigating program representative has received approval from headquarters and the field office supervisors to proceed with an investigation, they will complete that investigation using techniques including undercover vehicle operations, video surveillance, advertising review of ARD documents, and numerous other methodologies. Whatever it takes to capture the evidence to prove or disprove that the act has taken place. Once an investigation is complete, several outcomes could arise out of that investigation. The lowest level and our progressive disciplinary process is a proactive conference. This is used when the Bureau's concerns are at a low level, and we believe just through a conversation with the ARD, with the owner, the business practices can be changed to address our concerns. The next step in the progressive discipline process is an office conference. This was used when we have more serious concerns regarding the licensee's business practices. This is more formal. We ask the registrant to come into the field office, and we sit down and talk about what our findings are and what our concerns are, and really stress that changes need to be made to protect consumers. Otherwise, the Bureau may have to proceed to the next level, which is referral to the Attorney General for the filing of an accusation to revoke the ARD registration and our associated licenses, or to revoke our technician and adjuster licenses. We do not send cases to the Attorney General for the purposes of putting an ARD on probation. Generally, when we've gotten to that point where we're going to engage the resources of the AG's office, the ultimate outcome is we're seeking to revoke the license, because based upon the evidence we've captured through the investigation, that's the appropriate outcome. Now, obviously, if we file an investigation, or pardon me, an accusation, and once we file an accusation, if the respondents come up with evidence that we weren't aware of or we didn't capture through our investigation, certainly that may move away from a revocation, and frequently does. So some of the statistics of our investigation outcomes, in fiscal year 1920, of our formal investigations that were opened up, 371, 37% were proactive conferences, 109, 11% were office conferences, and then 52% were AG referrals. That has, in fiscal year 2021, we've elevated the number of our proactive conferences to, so far year to date, through December, and half of our investigation outcomes result in proactive conferences. So we're gaining compliance at the lowest possible level a little more frequently this year. I think, the 1920 statistics still bear out the fraud that we've been recognizing through data in the smog check program, which is why the high percentage of AG referrals. Now that we're kind of taking out the bad actors with smog check, we're able to address a lot of the concerns at a lower level now. So once the investigation is complete and we submit to the Attorney General, the Attorney General's office will assign the matter to a Deputy Attorney General, frequently referred to as a DAG. The DAG will review for sufficient evidence to sustain an accusation. It's not always automatic when we send a case to the AG's office that they're going to prepare an accusation. It's something they review it and determine whether or not they can present evidence at hearing and defend the case. Again, the ultimate outcome is always looked at as probable revocation, and that has to be sustained and defended at a hearing and with the evidence presented. If they agree that an accusation is appropriate, the DAG will prepare an accusation for bureau review. The case analysts in my unit compare the accusation to the investigative report for accuracy and works with the DAG to make any necessary edits to provide a clear and accurate pleading document. Once the final draft is approved and completed, it's presented to the Chief of the Bureau for final approval and signature. And the Chief does still frequently ask myself and my subordinate managers questions about accusations. That does review these, reviews everyone and signs them all himself, and often has questions for us as a further check and balance in the process. An accusation is considered filed. That's the start date of the formal administrative process when the Chief signs it. The signed accusation is returned to the Deputy Attorney General, who executes service on the respondent. Once served, when served, the accusation is accompanied by several legally required documents. The government code, the APA within the government code specifically requires several steps. And one of these documents is a blank notice of defense, which is a very important document because once a respondent receives the accusation, they have several options to address it. They must file a notice of defense within 15 days if they intend to defend against the accusation and contest the accusation. They must file a notice within 15 days and request a hearing before an administrative law judge. They can also file the notice of defense, and there's an option in there to request a settlement of the matter and to engage in settlement and negotiations. We often do that, and as you'll see later, but generally that's how most of our cases are resolved, is through settlement between the parties. They can ignore the accusation and not file a notice of defense at all. If a notice of defense is not received timely, the Director of Consumer Affairs, who's the ultimate decision maker in this process, will issue a default decision against the respondent. So, accusation resolutions, what are the possible outcomes? Default decision, again, that's if the respondent fails to file a notice of defense or does not appear at hearing. A stipulated settlement, that's it's kind of like a plea deal. who also knows it's a settlement of the accusation through mutual agreement between the parties. And then the final outcome is that it goes to hearing, and the administrative law judge will accept evidence from the parties, issue a proposed decision, including proposed discipline, and submit for the director's review. The key here is whether we settle a case through settlement, it's a default for failure to file a notice of defense, or it's the result of a proposed decision from an administrative law judge. The ultimate decision maker in every action is the director of the Department of Consumer Affairs, or her designee. It's always submitted, each matter is submitted, and the director has the final say in all matters. Accusation, how we resolve these accusations, statistics on that. As you can see, in fiscal year 2019-20, over half of our accusations were resolved through stipulated settlement, and the same is holding true for this year. The defaults are the lowest percentage, and then adopted proposed decisions going to hearing is right about 30% of our cases end up at hearing. So 70% of our cases never see a courtroom video hearing. The discipline outcomes per the Bureau's disciplinary guidelines, and there is a link to the bar disciplinary guidelines on this presentation. Hopefully that works on the presentation that's posted to the Bureau website. The specify what the outcomes of this can be. On rare occasions, an accusation may be dismissed or withdrawn. That may be at the AG level when they look at it and suggest that we withdraw the accusation and resolve at a lower level through an office conference or so forth. Occasionally, an ALJ will dismiss our accusation, but in my time in this unit, in a position that is extremely rare, I would definitely count on one hand the times it's happened, maybe once or twice. As I said before, we're seeking to revoke a license when we get to this point. We felt, generally the investigation has revealed that the behavior is either so egregious that to protect the public, we need to revoke the license or registration, or continued and repeated educational attempts have not achieved the desired goal. And the second outcome is revocation, but that revocation will be stayed and the license will be placed on probation. And the terms of that probation are specified in the disciplinary guidelines. They often, mandatory reporting requirements, right to access to records at any time, including while repairs are in process, terms similar to that. And then the final outcome is revocation stayed with probation and a suspension. The suspension is actually a term of the probation, and it would be specified in the final disciplinary order as adopted by the director. Again, as I said, accusations are filed for the purpose of taking disciplinary action against the registration or license. And that's key. We're disciplining the registration or license, not individuals. We deal in licenses at the Bureau. If we enter into settlement discussions, we will evaluate their mitigation provided, and that gives the respondent a chance to provide us with evidence that wasn't captured during the investigation that may move us away from revocation. And each case is settled on its own terms. We don't frequently, opposing counsel will say, well, in this case, you gave us these terms. Well, every case is different. There's mitigation, there's evidentiary issues at times, there's other factors in every case that makes it stand of its own accord, and each case is decided upon its own merits, settled upon its own merits. In addition, the ALJs will also reference the disciplinary guidelines in crafting the proposed decision, and they frequently, if not always, mention the disciplinary guidelines in their proposed decisions to provide substantiation for the recommended discipline they are suggesting. As far as probation goes, a period of probation per the disciplinary guidelines is between 2 and 5 years. Generally speaking, the goal of probation is for the respondent to demonstrate that they can turn the business practices around and comply with the Automotive Repair Act, the bar laws and regulations, and protect, keep the public protected. That's the Bureau's ultimate goal. That's our mandate. Another, as I said previously, a term of probation is also a license suspension. And in 2 slides here, we'll get to how often that takes place. The disciplinary guidelines allow for a period of suspension of the license where appropriate. It's limited to no less than 30 days and no more than 30 days per the disciplinary guidelines. These are consecutive days beginning on the decision effective date. The suspension provides the licensee the opportunity to reset business practices. And I was reading a proposed decision recently, and the ALJ contemplated in the proposed decision that a 30-day suspension would allow the licensee the opportunity to contemplate their business practices and evaluate what really took place in the case to make sure that that behavior doesn't happen going forward. It's really kind of a well-crafted explanation of the value of the suspension. A sign as part of the license suspension, and it's a term of probation, a sign must be posted by the Bureau to notify the public of the period of suspension and the reason for the suspension. It's important that for the disciplinary guidelines, that sign is only posted for the period of suspension. It is not posted for the entire period of probation. It is only for the period of suspension as specified in the disciplinary guidelines. So some of our outcomes, and these numbers in here include total licenses disciplines. As you can see, as I said, when the Bureau of Automotive Repair, when the chief files an accusation against a licensee or a registrant, the ultimate goal is revocation. We don't file accusations to educate licensees. So about 70% in fiscal year 1920 and then 2021 year to date result in revocation. And then 24% in 1920 resulted in revocation with the period of probation only, and only 8% of our cases resulted in a period of suspension. Year to date, because there's a lower volume of cases so far year to date, the number of suspensions is at 13%, but still it's a relatively small portion of the outcome of our accusations filed. The average day suspension for 1920 was 14 and a half days, right about 15 days. I don't want to back up a second here, so I got to remember the number. Of the 132 suspensions ordered in 1920, less than 100 were of a 30-day, or more than 100 of those had less than a 30-day suspension. A 30-day suspension resulted out of a stipulated settlement 23 times, and then the ALJ proposed a 30-day suspension in 9 of the cases. It's important to note that I drew a blank there. There was a point I was thinking of that I'll probably, it'll pop back up in a second, and my apologies. Fiscal year 2021 to date, 43 licensees received less than a 30-day suspension. A 30-day suspension ordered as part of a stipulated settlement was only done by the Bureau through negotiations 1 time, and then ALJ proposed it 6 times. And the part that I thought about, and you're going to see on a couple slides going forward here, the 30-day suspensions are generally in the area of licensees, smog check license, brake and lamp license, where the behavior really puts the public safety at risk or the environment at risk through fraudulent acts, through smog check program, or bad acts through smog check program or brake and lamp inspection program. That's why a 30-day suspension is more common in those realms, in those areas of licensure than in general automotive repair, because of the enhanced need for public protection. And this screen bears that out. So the types of licenses suspended in 1920, just an automotive repair dealer by itself only happened 4 times, and in 2021 year to date it's happened 3 times. But then in smog check stations and brake and lamp stations, obviously the associated ARD is also suspended at the same time as those. It's just I wanted to capture the number of times where it was just an auto body shop, a general repair shop, or a transmission shop that received that suspension. But as you can see, vast majority of our suspensions are applied to small check stations and technicians in both cases. Again, it's the small check program followed up by the break and rent program. Okay, there's one of those. There's a number I wanted to talk about. Yeah. We may have pulled it out, but there was when the Bureau negotiates a settlement, I have it on my screen. Yeah. There was a slide 16 that Pat and I had looked at and discussed, and it seems it's been pulled out. When the Bureau, so the average in fiscal year 1920, the average day suspension was 14.55 day suspension. The average day suspension as part of the stipulated settlement was 12.97 days, so right at 13 days. The average days of suspension for an ALJ proposed decision was 20.69 days, about 21 days. So when the Bureau settles the matter before hearing, the suspension period is typically less. Fiscal year 2021 to date, the average days of suspension is 12.8 days. Through a stipulated settlement, it's at 10.4, and through an ALJ order it's at 27.14. So our stipulated settlements, I would like, and this is the part that I kind of alluded to at the beginning of the outset of my presentation. Preparing this presentation has made me, I'm quite pleased with what I see. I don't get involved in every negotiation. That's generally done through the case analysts and their immediate managers. I do get involved if it's unique terms or if there's egregious behavior where a respondent is really asking for probation and or suspension, and their instincts and the direction I've given them tell them no, this is a revocation case. So this gave me the opportunity to look at how we're settling these cases, and I'm pleased. I don't have any, looking at all the cases that we've settled and that have been settled and outcomes, I don't have a single one that I would go back and say I'd like to do again. So with that, I think I'll open it up for questions.
Bill, I'm sorry, I don't know what happened to that. I think it was a slide that we developed after posting of the presentation and the notice that went out on around that Friday before the state holiday.
Right, I remember that was that one we were working on late into an evening one time.
So we'll add it to the slide deck post meeting, and people can see that additional slide. It was a new slide 16, I think you said.
Yes.
I'm having Zach look for it now. I don't know what happened, but it didn't get posted with it or updated on for your presentation and get sent to Sarah, our moderator. Excuse me. It may already be on the website. It just may not have gotten to the moderator.
Yeah. Okay.
We'll check on that. And what was the title of the slide before I open it up?
That's suspension statistics. It's a second suspension statistics. The slide I have up right now is, I believe the slide that's up now is slide 15, and this is a continuation of this one that gave the average days suspension. It broke down that first line for each fiscal year and included how the average days of suspension play out based upon a stipulated settlement as compared to an ALJ proposed decision.
So it is correct on the website. We just validated, but it did not get sent to the moderator. My apologies.
Not a problem.
I don't know if we can pull that slide up.
I know. Can I share content?
It's on the website.
This is the moderator. Bill, if you would like to share, you can click share at the top of your screen. It'll allow you to upload. Yeah, and you can also share your screen. Just be wary when you are sharing your screen. If you have pop-ups, coming up, they'll be seen. Yeah. Right. And also just be wary. Don't click over to Outlook.
Okay.
Nobody send Bill an email right now, please.
Yeah, I could see some of my counterparts. So I think what we see, this is the slide right here. Hopefully everybody can see this, that this is the slide 16 that we're talking about, and suspension statistics in fiscal 1920, average days 1455, stipulated settlement is 12.9, and an ALJ proposed is 20.69. Year to date for 2021, we're on our stipulated settlements, we're at 10.4, and ALJ proposed the average number of days of suspension is 27.14. So now how do I exit out of that? Let's stop sharing. Okay, I think I did that okay.
Very smoothly.
And no pop-ups, good.
Now, thank you very much for doing that. All right, I'm glad we found that slide. It is, as I said, available on the website, and it has been updated there. We just did not make sure that we had updated it with the moderator who had all the presentations for loading into the meeting. We send our apologies. All right, I'm going to open it up for questions and answers and comments from the advisory group members. I see a hand already raised from Johan Gallo with the California Automotive Business Coalition, LABC.
Well, I guess it is afternoon. Appreciate your presentation, Bill. There's been a lot of discussion amongst our members and other groups regarding this 30-day suspension, especially in view of all the issues that are happening with COVID and the impact that it's had on their businesses. We have some that are concerned that if 30 days is going to become the norm, many small businesses will not survive that. And I realize most of these decisions are being rendered by the administrative law judge. But again, looking at the impact on businesses and employees in many cases that may not have been even involved in the situation are suffering the consequences of that. And so I just wanted to make a comment about that because it is very concerning to all of our members and the various other associations and individuals I've been talking to about that.
Thank you for that comment, Johan. And we're very cognizant of that fact, that the impact that COVID has had on the businesses. And that's why you can see in the slide 16 that I just had to pull up, that when we reach an agreement, we've ratcheted down our number of days of suspension. We're very aware of it. There are still times where a 30-day suspension is appropriate, but we have, as I said, we have ratcheted it down for that very reason.
Thank you.
I think you've seen from this data Bill presented, it seems like most of those cases are reserved for repeated smog check fraud and clean piping or clean plugging or both, clean gassing, and it's not just an isolated instance. It's many efforts to circumvent the smog program.
And I do want to thank you, Pat, for the conversations that you and I have had trying to lay out this, what I refer to as a progressive disciplinary action for the various stages of infractions of the rules and regulations of the Automotive Repair Act.
Yeah, I just want to comment on that. Thank you for your comments, John. I don't want people to mistake progressive discipline for required steps. We have it with discipline of our own employees, for example. Progressive discipline ranges from a very simple counseling memo or an expectations memo that may be sent to an employee for violating various rules or laws or policies of the department or the state of California, and it goes all the way up to dismissal. Now, for someone who steals property from the state of California, we're not probably going to see time spent with an expectations memo, thou shalt not steal. it'll probably go straight to the top or elevate itself straight to the top. So I think I want to make that point that similarly, very serious actions will not be wasting time with a simple reminder, that you should not commit fraud or that you should not steal from your customers. And I make that distinction or make that point because we have similar issues that arise with our own disciplinary matters with our personnel. While we call it progressive discipline, there are some very serious violations that can elevate you straight to the top and cost you your job here with the state of California and with the Bureau of Automotive there. Questions, other questions or comments? Jack Maladona.
Thanks, Bill, for the presentation. I do have some questions starting on page 13 and 14, but I'll start on 13. So as a general understanding, I know when you go to the Attorney General's office and there is, obviously you go revocation for the bad cases, and then there's this idea of settlement or put people on probation. And really it comes down to generally three things in those cases. One, you put someone on probation and you have them repay or reimburse the state for administrative costs. That's the second thing. They have to pay a fine. And then the third thing is this, what we've talked about, suspension, or what we call a downtime. And obviously that the downtime is probably the most significant thing for the shop themselves. I mean, they know that they've screwed up somehow and they're going to go on probation. We know that the disciplinary regulations, which I have in front of me, but there are approximately 12 pages on the suspension that lists specifically how much probation someone should be on based on the regulation or statute they violated. So there's tables there, table A and B. It lists if you violate this, that's 2 years down, or if you two years probation, I should say. If you violate this section, it's 4 years or 5 years. Very specific. And then of course, the reimbursement, but then the 30 days or the 3 to 30 days, the disciplinary regulations really doesn't have a lot of clarity there, I should say. It's basically optional. There are cases where I know the BR does not have any downtime. And then there's cases where you have 30 days and then somewhere in between. There's really no, I guess, objective standard as how you come up with how many days down. And now I know it's been talked about, you have, with this environment with COVID, people are, businesses out there, restaurants and so forth, are fighting, the closures because, closing down someone for a week could be devastating and basically closing their business. So one of the things that I've raised, Bill, and I know this is controversial, but I think it needs to be raised and discussed, is whether downtime is still an appropriate or suspension is really something that's still appropriate in this kind of climate and going moving forward here, because not only does it hurt the shop themselves when you close down a facility, they're losing their livelihood there, it also can impact innocent employees who were not even involved in the particular run or undercover run or case, right? If a business has 25 or 30 or 40 employees and they weren't even involved in something like this, you're closing down a facility for 30 days, those people are going to be out of a job, on unemployment and so forth. So I guess I just want to, number one, raise this issue about the downtime, whether it's still appropriate. And if it is, I do think that it's something we need to talk about to provide further clarity, whether it's done internally, whether it's done through regulation or legislation. It's to me, some of the cases I've heard, it's a crapshoot. You just don't know. Why did someone get 30? Why did someone get 15? Why did someone get 0? It's all over the place. And I know that there's certain reasons, but they're very subjective. So anyway, I think this 30-day suspension or the downtime is something I think needs more discussion, more clarification for auto repair dealers out there, and that's where I'm coming from. On page 14, okay, go ahead. I'm sorry.
Jack, I want to jump in because before we lose a chance to respond to this, I don't want to get too far removed from this comment. I do want to, I appreciate the comment, very good comment. And I think, yeah, something we would like to take into consideration and work with the industry on. But I want to turn it over to Bill. Before I do, I want to point out, obviously the disciplinary guidelines are established in regulation. Certainly would be open to suggestions on how to update those regulations. As you know, the current ones that were adopted and are in effect since March of 2016 were worked on for years with the industry. So there was a lot of input, a lot of workshopping by prior bureau chiefs preceding my time here that led to that effort to getting them adopted. Actually, they got adopted on my watch, but a lot of work went into those, at least 2 chiefs prior to my coming on board here. So I think if there's an interest in looking at these disciplinary guidelines, in particular the range of the suspension from the minimum of 3 days to 30 days, certainly during the pandemic period, we'd be open to that. I also think this is a good opportunity for us to relay those concerns and to those who are in a position to issue decisions and orders. And that's why I want to turn it over to Bill before we get into your next comment or question. I think it's really important to lay out, because I think people think I as bureau chief have ultimate authority to make a decision and order on this. My authority stops, well, maybe Bill can correct me, after I sign that accusation. That's the charging document that says, here are the violations of our laws. And we think revocation is in order. After that, if it goes to a judge, there's Bill, I'll turn it over to you, but maybe lay out those roles of the ALJ and obviously the department director to sign off on any proposed decision that's rendered or issued from an ALJ, or even a settlement agreement that we have entered into has to be signed off by the director. Maybe you could elaborate a little bit more on those roles, Bill.
Well, it's exactly what you said, Pat. It's the chief of the bureau files the pleading document, the document that initiates the disciplinary process. And again, it's right here, it's filed. After that, it goes to after it's filed, it's served on the respondent, and then the adjudication process, as spelled out in the Administrative Procedures Act, takes place. And that process is that, one, the courts encourage settlement, especially during these times when they cannot have in-person hearing. We're having many more mandatory settlement conferences, although they're not mandatory because they don't take place in every case. But the courts encourage us to get together, and a settlement conference takes place with an ALJ present, acting as a mediator between the parties. It's not as formal as a hearing. There's no court reporter, and conversations are had. And I've sat in on a few of those recently, and the judges contemplate. It's a chance for everybody to lay out what's going to take place at hearing, and have an ALJ weigh in and say this is where the discipline is going to land at. And again, it's discipline. It's not punishment. It's discipline designed to make sure that the public is protected, and to make sure the facility understands the ramifications of what took place and the harm that comes to the public. But again, that's, I'm participating in those settlement conferences as a representative of the chief. But even if we come up with an arrangement that's blessed, if you will, by the administrative law judge, and a settlement agreement is reached, that still has to be drafted into a document that's signed by the respondents and the attorney general, and the attorney general has to recommend that the director of consumer affairs adopt that settlement. Even though we participated in those settlement discussions, me as a representative of issues of the Bureau of Tax. It ultimately still goes before the director, who reviews everything. The director's designee, which is currently the Legal Affairs Division at the Department of Consumer Affairs, they review it and they do have conversations with the director, I'm sure. And their actions are what the director's will is. And the director is all the bureaus within the Department of Consumer Affairs. This process takes place with them, as that is how it's spelled out in the Administrative Procedures Act, in the government code, that the director will be the final decision maker in all these. A case before a board, the nursing board, contractors license board, and so forth, those are reviewed and adopted by the board itself. But bureaus, the director, so the director is not adopting these decisions just for automotive repair dealers. She's adopting decisions for, and I'm drawing a blank on other bureaus, but there's a lot of them. Sorry, it's not I'm very familiar with Bureau of Automotive Repair, but not the other bureaus within. But there are several bureaus under the department that are all adopted by the Director of Consumer Affairs. So it's not just, and along those lines, the boards and bureaus within DCA, more than half of them use a period of suspension. And many of them use, ours is actually one of the lower periods of suspension. Many of them have up to 2 and 3 years. And these are chiropractic examiners. Their period of suspension is a minimum of 30 days. And that's somebody who cannot do business as well. Certainly, and I can't reiterate this enough. And then there's other one, nursing board. So theirs is in months, not days. Bureau for PPE is minimum of 30 days. So the suspension is not uncommon in the licensing realm, and it is used as a tool. As an ALJ said, mentioned this briefly. A suspension is necessary to provide respondent to contemplate how its actions in repairing the vehicle were fraudulent and to enact business procedures to help ensure that no other customer is harmed by the respondent in the future. So that's the language directly from a proposed decision that exemplifies why we use a period of suspension. Yes, we know, we're very cognizant of, especially during these times, when business is already down, that the impact that's going to have on real people, employees, and so forth. Well, there are some that would argue, and there's a argument to be made, that in many cases, those employees are the ones that actually had direct involvement in the acts. So suspending their ability to work for a while gives them the ability to contemplate their actions. So I just, like Pat said, certainly, well, yes, I want to be clear, this is the director's action. That's spelled out in the government code. That the legislature has set forth this procedure of how these decisions will take place. And once Pat signs the filing document, other than participating on his behalf in settlement negotiations, this ultimately is before the director, and it's the director's decision. And I've had the director, the legal affairs division, kick back decisions and say, no, this is not correct. You need to adjust it in this way. They frequently do that. So they do review every decision and look at it to make sure it's fair and consistent, because ultimately that's representative of the director's action. So, but we are, to Jack's point, yes. I mean, always we'll have discussions, can we lay out a table to specify the number of days of suspension? The 30-day suspension, again, in smog check world, where the actions of the technician in the station resulted in the improper certification of a car that shouldn't have gotten the certification because they plugged into the wrong car, or they scanned the wrong paperwork frequently and often. A time period to think about that and contemplate that is probably appropriate. And I know a lot of shops use suspension to clean and maintain equipment. So I think the data, once at slide 16, if you go to the website and see that slide 16, it will show, I think the Bureau is very fair. And it's, given that our average days of suspension is lower than the overall average when combined with the ALJ's proposed decisions. We're very fair, and we do contemplate all of these issues when suggesting a number of days of suspension.
Bill, I thank you for that response. Let me ask you this. I mean, how does the BAR determine how many days someone goes down? I mean, as I mentioned earlier, there's 12 pages on probation and how long. But I've looked at the disciplinary regulations, and frankly, it's optional. Downtime or suspension is optional. But if the BAR does require suspension under the guidelines, it just says 3 to 30 days, but there's no guidelines. It's like the Wild West. I mean,
Well,
how do you
okay, so
determine?
as an example, so say we have a case where we have a smog check station that issued multiple improper certificates because they can't seem to scan the right DMV paperwork. You know, they can't seem to verify that the consumer owns two vehicles. They own a 2002 Honda and they own a 2010 Ford F-350 dually. And the consumer brings in the Honda but has the paperwork for the dually, and they just scan it in and proceed with the smog check. You know, and they do that repeatedly at that station. That laziness, sloppiness behavior, sure, there's no willful intent there. They didn't have the dually come in and know that it wouldn't pass and then plug into the Honda. They just were sloppy. That we're going to look at that, and we're going to start obviously with any discussion of suspension. And Lou can speak to this. If I start out at where we want to land, we're going to end up lower. It's a negotiation process. It is settlement discussion. So we're always going to start, just like when you're selling a used car. You're never going to post what you think what you're going to get for the car. You're going to post a little higher to give room for negotiation. So in some of those behaviors, we're going to start out at 15 to 20 days, 3 weeks, 21 days. And we're going to negotiate back to look at landing around 10 to 12. Now, if we've got false and misleading statements that led to a consumer being taken advantage of or something like that, maybe not there was intent for fraud there, but sloppy paperwork resulted in a consumer suffering a loss because they received a used part instead of a new part. We're going to start at 30 days because that behavior resulted in more consumer harm. It wasn't sloppy behavior. It was still sloppy behavior like the technician, but the level of harm was greater, even though obviously the smog checker was harm to all of us when vehicles are improperly certified. So it's not a random finger in the wind thing. It's, we're going to look at the violations that occurred, the causes for discipline that are cited. And if we've got false and misleading statements, fraud, we're going to start at the high end. We're going to start right at 30 days. I'm going to give an example here without mentioning cases, but I know an undercover vehicle, we had a defective switch in an undercover vehicle, a defective electrical switch. And we took it to a repair facility, and the repair facility recommended several hundred into thousands of dollars worth of repairs. Charged us for those repairs, and then swap that switch with another identical switch in the system, and then put a new switch in place of the identical switch, and never told us about it, never listed it on the invoice. That one actually got a suspension period and probation. I wish I'd been involved in the settlement because I probably wouldn't have offered anything. If the culture in a repair facility is such that that's an acceptable practice, revocation is probably on order because they're sneaking around changing, and that harms consumers. Ultimately, again, we're disciplining facilities, make sure consumers aren't harmed. So it's not entirely Wild West. It's we make a proposal, respondents make a much lower proposal. Lou and I can have conversations about that because we generally start way apart, and we always land at a fair position. But we do look at the causes for discipline that are cited in the accusation, and the more egregious causes for discipline, we're going to start high and not work back much lower than 15 days. If it's sloppiness on the part of employees, or training can fix it, we're probably going to start at 15 and work back to 5 to 10. And again, less than around 10% of our cases result in a suspension.
Well, okay, and I appreciate that. Again, I just think this is an area where if there was more clarity, more objective kind of standards, I think it would be better. And I think it's something I'd like to continue to, or at least having these discussions, because there's a lot of subjectivity. I know what you just said, and so that range is very broad. But and the reason we're spending time on this because it's a very important issue to people who end up, like I said, they're potentially going to have to close down their business. I mean, their livelihood and investment of hundreds of thousands of dollars here. So it's very serious, and it's something that I think we need to at least resolve, have some more clarity in. You mentioned you don't take as many cases, or at least you don't have that many cases. Let me just go to the next page, 14, and I just want to highlight something because sometimes with statistics they could be somewhat misleading. But on page 14, you see on the bottom where it says 2021, the 2020 and 21 revocation, you've taken 265 cases so far. Those cases are shops that have been revoked, correct?
Correct.
Is that correct? Okay. So then the second category is revocation stayed with probation. Those are the cases, there's 65 of them, that you had people where you settled with no downtime, correct?
Correct.
Okay. The third category there is
Jack?
revocation.
Jack? Yeah, it's not necessarily settled, I don't believe.
Okay. Yeah.
It could have gone to an ALJ as
Correct.
well.
That is correct. Yes.
Yeah. I
Both of
agree.
those.
I'm sorry.
Yeah.
Yeah. It's either a settled or ALJ. You had 65 of those cases. No downtime. But then there were 50 cases that you had some suspension. And it looks like it's only 13%, which is a low number, but really you need to divide the 50 by the 65.
Well, those are licenses, not
Yes.
cases. So you're going to have multiple licenses with a smog or brake case.
Well, but I thought the revocation, those are the ones that are out completely, right? There was no. Can you go back to that slide 14? So yeah, I just wanted to clarify because I was confused from that slide.
I want to highlight at the top of the slide, the parenthetical reference to total licenses discipline.
Right. So licenses. So there was 265 that were revoked.
Yeah, licenses. Yeah.
They're gone. They're out of. You took them out. They're bad guys, right? Or whatever. They defaults or whatever. They're gone. But so then I look at the 65 that you dealt with, right? Licensees. They were 65, and then you had 50 that had the downtime suspension. And so I think it would be appropriate to divide the 50 by the 65. That would be, and to me, when I did that, it was 77% of the time that you had downtime, which is pretty significant. That's the way I looked at it. So I just want to make that comment because I think that the way it's divided there is not really a fair representation.
Jack, I think we ought to refer to this one as the leftover parts discussion. We'll agree to disagree.
Okay.
Because to Pat's point, and I wanted to go through that slide. This slide here, the license types suspended, and so of those 50 that were suspended, only 3 of them were actual ARDs. There were 8 stations, and then 16 brake and lap stations, and these might be overlapping as well. There might be there might have been 8 licenses. There might have been an ARD with a smog license, a brake and lap, and then a technician, adjuster, and technician licenses. So, worst case scenario, there were to get to your math here. Worst case scenario, there were 19 businesses closed down for a period of suspension when you combine these two. There were 23 inspectors and adjusters, technicians and adjusters that were suspended, that had downtime. So really, we gave more individuals downtime than we did actual facilities, 2021 to date. So, again, it's the leftover parts discussion. We're going to probably come at it from different viewpoints.
Yeah, and that's.
But I do, and I want to, let me see if I can get that slide back up that I had, that slide 16. There it is. So I'm going to share this again, try and do it properly. Okay. This slide here the average days of suspension when the Bureau negotiates it using the methodology I described to you that is somewhat subjective. Uh, in 1920, we were at around 13 days. Now we're around 10 and a half days, close to 10, as an average number of days. So those 50 licenses that were suspended, overall the average was 12.8 days. When the Bureau settled it, it was around 10 and a half days. So we've ratcheted it down in recognition of the COVID and of the pandemic and of the impact that shops are feeling right now. And so my concern would be if we go to the disciplinary guidelines and we set objective guidelines that in this violation you will get X number of days downtime. That takes away our room to negotiate. That takes away our flexibility to ratchet it down in times when we know shops are experiencing difficulty. And again, we've only given 19 facilities at most, and I would hazard to guess that it's closer to 10 with overlap of those licenses. We've only shut down 19 facilities at the most this fiscal year, giving them downtime. So we're cognizant of it. We recognize it, and making the DGs with a set suspension time takes away that flexibility to work with the respondents and come up with a fair solution that both protects the public. Because again, you got to remember, I'm looking at an estimate where a consumer was charged for something that they didn't get, and whether that's through mistake, and if it's mistake, that's the only reason they're keeping their license. If it was through a deliberate act, we're going to be seeking revocation. If shops are deliberately stealing from consumers, we're going to be seeking revocation. But if it looks like it's a training issue, then but we still have to protect that consumer, and I still have to be. So my balance, and you can't see, here's my hands. My balance that I struggle with. I came from this industry. I spent 27 years in this industry before coming to bar, and I've run repair facilities. I've had consumers. I've had consumer complaints. I've dealt with all that, and so I'm very firm that we take the repair facilities, the restaurants into a consideration when we're settling these. But we also have to consider the consumer, and that is our mandate. We have to protect consumers. You're aware of that, I know. So again, I still think the O-ring should go back to the consumer, but we can talk about it going forward. We will talk about it. I look forward to those discussions.
All right. All right, Bill. We can agree to disagree, but I appreciate your comments. Thank you.
Yeah.
And just to reiterate again, when you say we, Bill, we shut them down, it is the larger we. It's a judge is sometimes involved.
Yes.
Settlement agreements often include legal counsel that has signed off on shutting down the shop.
Right.
So representing their client. And then ultimately, the larger we, includes the decision and order that's issued from the department itself and the department director. So let's move on to additional questions or comments. And if that is fine with Jack, maybe come back to Jack if he has any remaining questions or comments. Bud Rice, I see your hand is up.
Yes, hi. I know we've had this conversation before, but it has to do with the topic of a industry ombudsman. Because what happens to a shop is, by the time they know they've got trouble, their first reach out could be to the rep that might be the one that's yelling at them already. Or maybe he goes to the office manager who's also already teamed up with the BAR rep that's already yelling at him. So he doesn't have anywhere to go that could be someone who could help explain the process, what's going on, what his next steps or actions could be in relationship to trying to get this resolved. And in many cases, they're left with going out and trying to hire an attorney or a lawyer. And as many of us know, most lawyers don't understand how this whole process works either. So they end up with on-the-job training, trying to figure out how to represent the shop correctly with working with BAR and with the the powers that be, and so they're kind of stuck. I mean, the chances of them being able to run into Lou or Jack or something like that with someone that has some experience isn't, it isn't very good, in terms of them being able to luck out and getting people that understand the process. I know that there's budget constraints. I know that all this stuff costs money, but to have a place for somebody to go to at least get the process explained to them isn't necessarily an advocate for them, but can at least explain the process so they understand where they got turned in here sideways, what their options are to try to get to a resolution, and that kind of thing. And I think, and again, we've had this conversation before, but some kind of an industry ombudsman could be valuable in that situation. That's my comment.
All right, thank you, Bud. Yeah, certainly if an accusation's been filed, I think we passed the point of an ombudsman role. The best thing to do is obviously, at that point, I would advise the licensee to hire an attorney to get representation. Obviously, we can't advise them once an accusation's been filed, so an ombudsman wouldn't serve any purpose there. I certainly see your point with respect to any handling of consumer complaints and compliance with laws and maybe explanations that went along with the mediation of a consumer complaint. But again, if an accusation has already been filed with serious charges looking to revoke the license, I'm not sure the role of an ombudsman could play at that point. Next questions or other questions? See who else? No, I don't see any other questions. Jack, did you have anything else? No?
No, thank you. I nothing else. Thank you.
Okay. Okay, we can circle back. Let's look at questions. Let's open it up for public comment. Moderator, if you would please open it up to allow for public participation.
All right, this is the moderator, and at the direction of the Bureau Chief, I have opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this agenda item, please click on the icon with a question mark within a square located at the bottom right-hand corner of your WebEx screen. I'll go ahead and pause a moment to allow the public time to access that Q&A panel and submit their requests. All right, this is the moderator. It looks like there are no requests for public comment. Would you like me to close that Q&A panel?
Yes, please.
All right, Q&A panel is now closed.
Circling back for additional questions and comments. All right, Lou Anapolsky. Excellent, Lou. Good to see you. Your voice is rather faint. Is there a volume issue or?
Can you hear me now?
Much better.
Okay, all right. Bill, thank you for the presentation. What I'd want to do is just do a little backfill on the process that you laid out and give some more information to our viewers and our participants about the investigation process and what happened. I think it's important to understand what BAR is up against and what they do in terms of the initial investigation. Once BAR determines that they're going to conduct undercover operations or an undercover operation, an undercover car is selected, it's set up in an undercover laboratory or a facility around the facilities around the state in which the laboratories are used to set up the undercover car. The undercover car is then run into the shop. An undercover operator is the person driving the car and posing as the owner of the car. The undercover operator could be somebody directly employed by bar. It could be somebody who is not necessarily directly employed by bar, but directly back in the cover operation for specific operations. They run the car, they get the documents, they have interactions with the shop, they get the documentation from the shop, they go back to bar with the car. Bar then takes a look at the car and determines what happened based on how they set it up and what the shop did. Now, the reason I tell you this is because the bar does not have access to what we as defense lawyers have access to. The bar doesn't speak to all the individuals involved in the undercover operation. Their only contact is through the undercover operator, and that undercover operator the undercover operators have different degrees of sophistication in terms of what they're doing, and knowledge about the automotive repair industry, and knowledge about automotive repairs in general. So the bar is acting from an information deficit, so to speak, in the sense that what their source of evidence and information is about this undercover operation is really directly from the undercover operator. They don't have access to the people who did the repair. They normally don't have access in the operation to the shop owner. And it's up to us to go behind the scenes and find out really what happened and present the rest of the information to the bar. So people like Bill Thomas, they can see the whole picture. Not just what happened in the undercover operation, but they can see the whole picture. And that's what we call evidence in litigation. And Bill needs that evidence so he can fairly look at the case, not myopically, only through the view of what the undercover operator did and saw, but the larger view. And when Bill and enforcement has the rest of the information, they're no longer in a vacuum. They can make a more informed and hopefully a more balanced decision about what discipline should be in this case. Many times they're not aware of things that happen. They're based on the evidence they have to assume that there was a certain intent involved. It's up to us to demonstrate that intent is not there. And they do take that into consideration in terms of severity of penalty. The administrative law process that bar follows is governed by the government code, something called the Administrative Procedure Act. And not only bar, but
I apologize, Lou. This is the moderator. It's a little difficult to hear you. Is it possible that you can either get closer to the mic or click that arrow next to your microphone icon and fiddle with your audio settings?
yes,
Thank you. It was just a little bit hard. I was getting maybe every other word.
is this better now?
That sounds a little bit more clear, yes.
Okay.
Thank you.
All right, so the Administrative Procedure Act, everybody has to follow that. There's not a lot of discretion that comes in terms of the administrative process itself. For example, what Bill started to talk about but really didn't fully explain is when the case goes through negotiations and we're able to arrive at a stipulated settlement and disciplinary order, Bill's right. The bar signs off on it, we sign off on it, and then it goes to the DCA for approval. Most of the time, the DCA will agree with the agency, the bureau, or your boss. Sometimes it doesn't. If it doesn't, then the matter goes back to the administrative law courts for hearing. But even if it goes through a hearing, this is what clients have a hard time understanding, as many lawyers have a hard time understanding. You try your case, the bar puts on their case, they call their witnesses, they put on their evidence. They rest. We put on the defense case. We call our witnesses. We put on our evidence. We rest. The judge then is required to make a proposed decision. And the key there is proposed. That's the word proposed is what you have to focus on. And the reason it's a proposed decision by the administrative law judge is because that decision first goes to the agency for adoption. The agency has 100 days from the date of the issuance of the proposed decision to either adopt the decision or not adopt the decision. If they do nothing in that 100-day period, it becomes adopted by operation of law, so automatic adoption. If the agency doesn't like the proposed decision, the agency can reject the decision, issue what's called, well, call up the transcript, review the entire transcript, all of the testimony, all of the documentary evidence, and then write what's called an alternate decision. And that becomes the decision of the agency. So, because of the prospect of a decision of the administrative law judge being the proposed decision may not be the final decision, it's really important that clients understand that you need to go through trial. And you do well at trial. It's just a proposed decision. That doesn't necessarily mean it's going to be the final decision. Now, in all the years that I've been handling bar cases, I can honestly say I've only got, I believe, 2 cases that we settled with bar that were rejected by the DCA. And I don't think, I'm trying to think, I don't, and when I say rejected by the DCA, those are stipulated settlements. And I don't think any of the cases that we tried, I can't think of a case where the bar took the proposed decision and decided they were going to do something different. They adopted what the administrative law judge found to the proposed decision. So the process of administrative law is very frustrating for many lawyers. As somebody said, if you're not versed in administrative law, it can be very, you could be spinning your wheels and having to learn an area of the law that maybe at your client's expense. But be that as it may, the job of bar trying to figure out in any given case what is a fair resolution, it rises and falls on the strengths and weaknesses of each case. I'm very nervous if we're going to try to standardize any type of like suspension. As a defense attorney, I need the flexibility to look at each case independently, looking at its strengths, looking at its weaknesses, and being able to talk to bar about each case as an individual case, both the good and the bad, so we can figure out what is a fair resolution. That's all.
Wow, thank you, Lou, for the explanation. That was a lot of information, great information. Appreciate you filling in some of the gaps that we may have left out in our explanations and the presentation that I provided. Very good stuff. Thank you. Further comments and questions from the advisory group? Okay. Well, I wanted to say one other item relative to this. I've been working on a regulatory package which was going to allow for training, simply that, just training to be that's missing currently from the disciplinary guidelines as another item to consider. In sometimes we have orders, proposed decisions from judges that include training. I'm not sure where they get that because it doesn't necessarily exist in our disciplinary guidelines, to my knowledge. So we are looking to add that feature and also have that is something we can recommend through the settlement process of our cases as well. So given that we are looking to open up the disciplinary guidelines themselves, I won't dismiss certainly would welcome any interest in looking at other areas. I think we've heard some of the cautions from Mr. Anapolsky with respect to setting exact standards in those disciplinary guidelines for each violation. But certainly I'm not going to dismiss someone's interest to have us take a look at various aspects to those guidelines that have been on the books for almost 5 years now. So if there is something you would like us to take a look at, as we look at adding a training feature to the disciplinary guidelines, or a training requirement to any disciplinary order, that is something I'll entertain. We don't have to answer that question or don't have to get ideas today, but as those regulations are moving through the public comment process, that would be the time to raise those issues, I think. It would be a good time at that time to do it. Any other questions or comments? All right. Bill, thank you very much for the presentation. Don't let that presentation go too far. We might have to give it again in a few years, because I think all of this is, we need reminders, a refresher on some of these aspects of the administrative law.
Yes, thank you, Pat. And I wanted to say thank you to Lou for cleaning up my mess, so to speak, and covering the things I missed. But no, I enjoyed his comments as well, and I enjoyed all the comments. Jack, Bud, Johan, everybody's comments are greatly appreciated. We're always open to them, and we're, as you say, frequently, we're willing and ready to work with the industry to make it effective from all sides. Thank you.
Oh, I had another hand raised. Nikki Ayers.
Hi, thank you. Did I hear right that even if the ALJ makes a decision and it comes back, that the department still has the option to look at what the decision was?
It's a proposed decision from the ALJ. Emphasis on the word proposed.
Okay.
Yes.
It's really almost a recommendation from the ALJ. Now, the department typically follows them fairly closely, but it is a proposed decision, and it's ultimately the directors of consumer affairs decisions, and as we've said several times, not Pat's, not mine, whether or not to adopt that decision. And then also, even if the proposed decision is issued and the director adopts it, the government code allows reconsideration, and the respondent can petition, as provided in the government code, can ask the director to go back and take a second look at it, and can actually submit evidence as to why the ALJ may have erred in that decision and ask for something more appropriate. That's called a petition for reconsideration. We get them frequently. I would say probably 10 to 20% of our cases we see a petition for reconsideration. And I know the department, they frequently ask us for evidence and documents and other artifacts related to the case to evaluate that request for reconsideration. So I know they take a thorough look at those when they happen.
Yeah, that has come up. Bill says on occasion. You mentioned the percentage of time. It came up as recently as yesterday on a case, and we referred the individual to Government Code Section 11521, which allows for a petition of for reconsideration of the decision that was rendered by the department. All right. I thank you all for a very lively, entertaining discussion on this. We look forward to continue working with you on these issues. Moderator, you may close this agenda item. All right, our next agenda item is our quarterly enforcement statistics update. It's a handout only, but we do open it up for any questions that might, if you saw some numbers or data or statistics in the presentation that didn't look right, or you wanted, certainly with the pandemic, if any numbers seem to have changed from last year at this time that you want to ask clarity on, certainly would entertain any questions from the advisory group. I did get, someone asked earlier about auto body shops. Someone had told me, and I don't remember what our answer was, but someone ran a report with ARDs that have listed auto body as their primary repairs being performed is currently 5,448. So I'll ask any questions or comments from the advisory group regarding the enforcement statistics update for Q2. I don't see any hands. We can open it up for public questions and comments. Moderator, please do so.
All right, this is the moderator, and at the direction of the Bureau Chief, I have opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this agenda item, please click on the icon with a question mark within a square located at the bottom right-hand corner of your WebEx screen. I'll go ahead and pause a moment to allow the public time to access that Q&A panel and submit their requests. All right, this is the moderator. It looks like at this time there are no requests for public comment. Would you like me to close that Q&A panel?
Yes, please do. Thank you.
All right, the Q&A panel is now closed. Oh, I apologize. Someone sent in a question right as I was closing it. Let me go ahead and open up the attendee list. Looks like individual identified as James. James, I'll be unmuting your microphone now. I please ask that you do keep your comment to around 2 minutes. I'll be unmuting your microphone now.
Thank you very much for the time. I was just wondering if there's a way to see this handout, if you plan to put it up on the screen at all. I couldn't find the actual document online.
Oh, well, it is on our website, but yeah, we could. What exactly was there? Oh, you can't see, so we'd run. Yeah, it's only a handout because it's become fairly routine information. Has various data. I think it'd be good if we.
I can check the website. That's fine.
Yeah, we can send you a link. Do you have can you send us, let's see, your email address, and I can send you the link to it?
Yes, I do have it. My email address, yes, it's on here on the account.
Do I have it, or the moderator has it?
This is the moderator. Unfortunately, it does not show me the email addresses on my end. Is there an email address that James could email
Yeah,
for Bar? That way he's not giving his email address out on a public meeting.
I was going to suggest the same. So
okay, wonderful.
Everybody knows my email address, so let's give that. It's yeah, we'll send you the agenda and the link to it. But let me give you my email address so at least I can get your contact information, James. It's patrick.dorais, DORAIS, @dca.ca.gov. If you send me an email, I'll send you a link to all that information on our website, including this presentation.
Perfect. Thank you so much.
And if you'd like to be added to our interested parties list so you get this information about public meetings and and the notices. I'm not sure how you found out about this meeting, but if you didn't get it because if you got it from someone else, be happy to add you to our interested parties list. All right, we'll close this agenda item. Our next agenda item is for public comment on items not on the agenda. So for anything that hasn't already been discussed, this is an opportunity to bring those issues up. Anything from the advisory group members? Seeing none, we'll move to public comment. Moderator, if you would please allow for the public to ask or comment on anything that wasn't on the agenda.
All right, this is the moderator, and at the direction of the Bureau Chief, I have opened up the Q&A feature for public comment. Members of the public, if you would like to make a public comment on this agenda item, please click on that icon with a question mark within a square located at the bottom right-hand corner of your WebEx screen. And I'll pause a moment to allow the public time to access that Q&A panel and submit their requests.
Okay.
All right, this is the moderator. It looks like at this time there are no requests for public comment. Would you like me to close that Q&A panel?
Yes, please. Thank you very much, moderator.
Oh, I apologize. Someone sent in one right as I was closing it. Individual identified as Wes Taylor. Wes, I'll be unmuting your microphone in just 1 second. Just as a gentle reminder to please keep your comment around 2 minutes. I am unmuting your microphone now. This is a moderator, Wes. Unfortunately, if you are speaking, I cannot hear you.
Sorry about that.
Oh, now I can hear you. Thank you.
Yeah, this is Wes Taylor with Chivy Lube. Chief DeRay, members of the advisory group, thanks for letting us listen in. It's always appreciated. I did one question. On the last meeting in October, we were talking about the repair citations comment, and the Bureau presented on that. I was kind of surprised we hadn't heard on that this time, this meeting. Is there any updates on that particular topic?
Yes, I can provide a quick update. We are working on regulations after having done was it a presentation? It wasn't a workshop, but it was a presentation at our last, I think it was our October meeting, October 2020 meeting. We are working on putting kind of pen to paper or typing away draft regulatory language relative to those kind of rough ideas that we had sketched out for that meeting last October. Staff are working on that. My apologies, I'm getting a phone call. Thought I had it on mute. So we are working on those draft regulations, and we'll have, I hope, a draft that we can workshop in conjunction with our advisory group meeting in April, which is our next agenda item, coincidentally, is the mention of our next advisory group meeting. We'll have an advisory group meeting in the morning, going till 1 o'clock roughly, as we are doing today, and then we'll hold a regulatory workshop, at least one, if not two, on the afternoon of that same day, April 22nd, 2021. And this will be one that I think will be ready to go for a regulatory workshop with draft language. Does that answer your question, Wes?
Yes, it did. Thank you very much. I appreciate it.
Yep. Yeah, there wasn't enough to report on for this meeting, just a lot of behind the scenes work of the staff, taking in all the comments we got from the presentation last October. All right, so this agenda item, again, just a reminder, everyone, that the next bar advisory group meeting will be next this coming April 22nd, 2021, also a Thursday. And we already know we have at least one agenda item with the Cash in the Can outreach program presentation that had to be moved from today's date to April. So we have that one scheduled, and then any other additional items that you would like to take into consideration. I'm sure we have a few things on our plate that we'd like to update you on. But if you have anything that you think would be good, we'd be happy to entertain it for a possible agenda item for our next meeting in April. It doesn't have to be today. You can email me or Zach, our assistant here in the executive office, Zachary Richardson. All right. I don't see any questions or comments regarding that. It's usually just an informational item. All right. I think we're ready to adjourn. I just have one final comment, which is thank you all for your presentations from the Bar Advisory Group. I want to thank you for your excellent questions and comments that always keep us on our toes, make sure that we're no stone goes unturned, as they say, that we're looking at all aspects of our regulatory authority before we jump into the deep end of the pool with various aspects of our regulatory authority. So keep it coming. We appreciate your input. I'm sorry the meeting ran longer than was scheduled. I believe we do have an out with some language that allows for us to say that or until close of business. But we usually try to get these meetings out by 1 p.m. And I do appreciate your indulging us with somewhat of a lengthy discussion, but a very important one on the discipline and investigation and discipline process. So I think we were probably lucky, unfortunate that maybe one of the presentations wasn't able to be given today. I'm sorry it didn't happen, but at the same time, we would have been even further beyond our 1 p.m. goal for concluding this meeting. So thank you all for your patience and your efforts to make these meetings very productive. Again, thank you to the staff and all of the advisory group members, as well as our participation from the Department of Toxic Substances Control. I appreciate their efforts. Last but not least, I can't thank the Department of Consumer Affairs and their moderators that are provided to us for these WebEx meetings. Did an excellent job. Sarah Arani, I now will call you no longer moderator, Sarah Arani, and Bill Zarniello, I believe is his name. Bill, I haven't had a chance to work with you too much, but Sarah and you have done an excellent job getting us through yet another virtual meeting, and I appreciate your efforts. Thank you so much all for attending, and we'll see you in April. We're adjourned.